The next case is Genesee County Drain Commissioner versus Genesee County. This is also a MOA. You have 15 minutes. Ms. Masseron.
May it please the court, Mary Masseron on behalf of Genesee County. Genesee County urges a reversal in this case because the Court of Appeals erroneously held that the plaintiff's claim for unjust enrichment sounds in tort, even though it was a mere relabeling of factual allegations arising out of fraud and conversion claims that had previously been dismissed. In Ray Bradley estate, this court announced a test for tort liability that would, if applied here, mandate a reversal. That is equally true whether the court applies Bradley as a bright-line test, looking at the nature of liability arising from factual allegations, or if it chooses to dive into the conceptual framework for unjust enrichment. The commissioner's argument fails because it's based on a confusion of the nature of an implied-in-law contract as opposed to an express or implied-in-fact contract. Acceptance of that approach would eventually return Michigan's common law to the forms of action and the technicalities of the old system of writs, something the entire modern thrust of law has been to abolish and get away from, for all of the reasons that I think the justices on this court know. Looking to the nature of liability, if it's a failure to comply with an obligation imposed by law, that is, an implied-in-law contract, it sounds in tort. If it's a failure to comply with the party's agreement, whether express or implied in fact by the circumstances and conduct, it's an obligation that the standard is set by the party's agreement, not by the law, and in that case, it's a tort. If I have any more of my fire-free time, I waive it.
Counsel, good morning. Shouldn't we look at the action in a more holistic approach? Like, under your argument, wouldn't this be a overly simplified way of approaching it? Don't you have to look at this in its totality in terms of when you're looking at a claim, you have to look at the claim, again, in a more holistic fashion?
I think that it is a simple test, but it is one that is based on looking at the factual allegations and the claim as a whole. It's a simple test because it follows what this court has said on multiple occasions, not just in the context of immunity, but in the context of the labeling of motions and other kinds of labels. What the court has said is, we don't look at the label, we look at the substance. So in this case, we don't look at the label, unjust enrichment, we look at the substance. What is the substance? You look to the second amended complaint, and you can see the factual allegations are almost identical to those previously pleaded as fraud and conversion. And in that circumstance, the indisputable conclusion, at least from our perspective, is it's a tort, it's not a contract. There's no allegation.
But if I were to use that analysis, I mean, basically in any kind of contractual dispute, couldn't you just kind of then come back and argue, well, wait a minute, I mean, wouldn't this be a very expansive reading of GITLA in that perspective? Like, it would allow for it just to be quite expansive if you just have a general contractual dispute.
What the court has said traditionally is that if you can plead a contract, that is a cause of action that's based upon the party's agreement, either by words, written or oral, or by conduct that shows mutual assent to some behavior or exchange, in that case, it is not going to be barred by immunity. And that's different than, I think, the Colorado case or some of the cases where they say, if you could plead either, you can't bring your contract claim either. We are not urging this court to adopt a rule that if the single transaction or occurrence could give rise to a tort claim and also a contract claim, therefore the contract claim is also barred. But what we are saying is when the nature of the claim, the nature of the liability that is, that's being pleaded, is not coming from the parties' mutual assent by words written or spoken or by conduct, but is coming from some obligation imposed by the law. In that circumstance, it sounds in tort. It should be treated as a tort. I think Bradley said that in looking at the Queen's Bench and the whole history. It's like civil wrongs. Bradley said, let's look at the whole history. They divide into these two boxes: contract on the one side, no immunity; tort on the other side, immunity. And these labels are not going to make a difference.
But counsel, isn't that what's in dispute here? This is not necessarily a binary world in which there are two kinds of civil wrongs, the tort claim and the contract claim. If it were, you would certainly be right that this not being a contract claim, it must be a tort claim, and you would be protected. Question I have is whether the world has changed since the Bradley Estates case, and whether there's a third category that encompasses things like the unjust enrichment claim. Otherwise, I can't understand what the point of the second prong in the Bradley Estates case was, which goes beyond simply asking what the first prong does, which is whether it's a contract claim or a tort claim.
Bradley says the test is, let's look at the nature of the liability. And that is the test that applies here. I don't think we can say that the world has changed since Bradley. I mean, Bradley looked at and traced this whole common law history and came to a certain conclusion in a strong majority opinion of the court. So to now come back and say, no, we're not going to treat it as sort of binary. We're not going to say if it's a civil wrong, it's going to fit into one of these categories.
But the argument I have is that Bradley is not binary. If Bradley only had the first prong, you would be right that it would be looking out across a binary landscape. But it's got the second question, which asks something about whether the case resembles, what's being sought resembles compensatory damages. So it's not necessarily that you would lose if Bradley were revisited, but Bradley creates some unknown third or fourth kind of component that goes beyond the two wrongs of the tort claim and the contract claim.
Well, and again, I would say with respect to that, the compensatory damages element was, I think, probably very important in looking at the contempt facts, because what that certainly appeared to be was an effort to provide compensation under the guise of the contempt power of the court. And Bradley said, no, you can't do that to get around immunity. Here, what we have are factual allegations that were originally pleaded as conversion and fraud, and they're the same factual allegations because the nature of the liability here
But that's,
is...
the fact that the unjust enrichment claim didn't come till later just might mean, they should have thought of it first. Maybe they should have led with unjust enrichment. I think it's distracting to keep saying, darn it, they came up with that later. If it fits, maybe the claim will fail for lots of reasons. But I find that argument sort of distracting. Like, let's just talk about whether unjust enrichment might be neither contract nor tort. And if so, why doesn't it survive?
It doesn't survive because what it's essentially presenting is an implied in-law contract here. If you look at Garner's definition...
Doug Laycock would not agree with you, right? I mean, Doug Laycock would say, you quote from the opening of the restatement to say that unjust enrichment often sounds in tort, and that's not what it says at all. It says that the identification of unjust enrichment as an independent basis for liability in common law legal systems, comparable in this respect to contract and tort, was the central achievement of the 1937 Restatement of Restitution. So I think it's like long before Bradley, unjust enrichment was its own claim. Like, civil law wasn't divided into two claims.
What Laycock says is that it can be brought as an independent action. When you take that, though, and ask what's the nature of the liability, which is what Bradley did, you have to look underneath that label. And if you look at the third restatement, and I think this is important, look at the chapter, all of the sections dealing with wrongs, including those that are factually the kinds of wrongs that we are dealing with here, the drafters of the third restatement specifically said, and I think I've quoted this in my brief, this section, that the nature of unjust enrichment in those circumstances is intended to be parasitic. That's the word. Because it's not intended to exist where it isn't sitting on some top of something that could be and is a tort. And in that circumstance, it seems to me we need to apply Bradley and look beyond the label to the conduct. And the conclusion from that is it's barred by immunity.
So you want the court to write an opinion saying unjust enrichment is more like a tort than a contract, so it's, I mean, isn't that a lot of work for us to do to get to immunity? I mean,
It's not a lot of work at all. The point is, you look at the section, you can look at the restatement, and you can look at the section that deals with wrongs, and you can look at the language in the section. Or you can simply look at the nature of the factual allegations and ask, what is the nature of the liability here? And it sounds in tort. It's an obligation imposed by the law for conduct that the law deems unjust or wrongful. That gets you exactly to where Bradley takes you, which is an opinion saying governmental immunity applies.
Can I ask, doesn't the first paragraph of plaintiff's complaint say that the parties, your client and their client, entered into an agreement? Maybe it's not a written contract, maybe it's not enforceable under that theory, but for their agreement to join forces in the way in which they did in order to secure health insurance for their employees and all that comes from that, why is that not akin to a bargained for exchange, that if they can't, even though they didn't memorialize it in a written contract that could be enforced as a breach of contract, why is that not the equitable equivalent of a contract claim?
The commissioner has a contract claim. The contract claim is still pending. And they make that allegation, and at some point, the trial court will look at that allegation, and they'll come forward with their proofs of why they think there's written or oral agreement or
But if-
conduct manifesting assent.
If they reject the contract claim, though, I mean, and in fact, if there is a contract, then an unjust enrichment claim can survive. But, so why is it not which is done all the time, it's the alternative to, I think I have a contract, but if I don't, I still have an enforceable agreement, bargain for exchange in equity?
Because the quote-unquote bargain for exchange, I think that's blurring these two separate concepts in the common law. Common law is very clear, and you can look at the Dobbs Treatise, you can look at Brian Garner's definitions, you can look at the Restatement of Contracts, second section 4 comments A and B. They all make this distinction between an implied in law contract, which is not fundamentally contractual. It's not based on an agreement. There was no manifestation of assent. It is based on an obligation that courts have concluded should be imposed upon one party or another for a certain kind of conduct. That's not the same as a contract, whether it's express, oral or written, or a manifestation of consent. So the implied in fact contract is an entirely different concept, and it's gotten blurred in the briefing in this case, and I think in the thinking about this case. The Cannon case, the Rocco case, these cases, if you read these cases carefully, what they are talking about is implied in fact contracts, and what they're saying is there was conduct back and forth that we as a society recognize as the kind of conduct that gives rise to an enforceable agreement between parties, and we will enforce that as a matter of contract law. And Ross, recognizing those situations, said, okay, those situations are not barred by immunity. We are not talking about facts that are in those situations with respect to this unjust enrichment theory. What we're talking about is allegations that you defrauded me, you misrepresented, and you took my property and kept it wrongfully. That's fraud and conversion. I want to say also, if the court goes down the road of recognizing this as an exception to immunity, it's opening up a gaping hole in the protection that has historically been afforded to government, state and local. And it's doing it in a way that will be encouraging the kind of artful pleading.
Can't the legislature just write a government unjust enrichment liability statute? The government can say you can't sue us for unjust enrichment, but the legislature can do that.
They wrote a statute, Justice McCormick.
They wrote a statute about tort liability.
And so to say we can just go down this road and then let them fix it, I mean, I don't think that's
They
satisfactory.
wrote a statute about tort liability. I'm suggesting they could do one for unjust enrichment liability too. They can make the government immune from whatever they want. That's fine.
They have,
Tort liability.
correct,
Yeah. Okay. Thank you. You
correct.
have something else to say? Yeah.
Well,
Your time is up, so-
I'd like to save a minute for rebuttal.
Your time is up. Sorry.
Well, can I ask you one more question?
You're going to have to answer now.
Before your time is finally consummated? Compensatory damages are typical of a tort, and those are defined on the basis of the loss suffered typically by the plaintiff in a lawsuit, in a civil lawsuit. What we have in unjust enrichment cases are not that kind of compensatory damages, but damages are determined on a different basis, on the basis of the gain garnered or drawn by the defendant. What is the relevance of that distinction in terms of the characterization of the second prong in the Bradley case, namely the resemblance of the case to a traditional tort case? Doesn't that draw it away sufficiently from a tort case?
I don't think it does. What the commissioner is seeking is the monies. I mean, to me, that's a...
It's not just this case, it's the next 100 cases too,
Right.
as we're wont to say. And all those 100 cases are going to define in unjust enrichment cases what it is that the defendant typically will have garnered from whatever action caused him to become unjustly benefited. It will not be defined on the basis of what the plaintiff has identified as his or her or its losses in that case.
Again, I would say you can look at unjust enrichment as having a different view of what's collectible, but in many cases, and this is one of them, that's going to be the same as a compensatory remedy. I mean, you're looking at the same thing. It's a question of how you label it. If the court wants a system of technical labeling as a basis for governmental immunity or liability, you can go down that road. But it seems to me that's contrary to the adoption of the 1963 Rules of Civil Procedure, which abolished those kinds of distinctions. It's contrary to what the court's rationale and rule was in Bradley, and it really does violence to the protection that the legislature intended for local and state governments to have in Michigan.
Any further questions? Thank you, counsel.
Thank you.
Good morning, and may it please the court. My name is Scott Frame, and I represent plaintiff, the Genesee County Drain Commissioner. I'll get right to the point. The issue is whether the Court of Appeals erred in its decision in this case. I would submit it did not for two reasons, and those reasons follow the two prongs under Bradley. So I think that's where we all need to focus in this case, is Bradley in the application of the two prongs to the claim of unjust enrichment. The first prong that for which Bradley gives us guidance is whether the wrong alleged is premised on the breach of a contractual duty. And I emphasize the word premised. Bradley doesn't say it must be a contract. It says it must be premised on a contractual duty. Therefore, the question is unjust enrichment premised on a contractual duty? And I would say there's at least 4 reasons why it is. The first is historical precedents. We have numerous cases in this state holding for a long period of time that unjust enrichment is a quasi-contract, is the equitable counterpart to a legal claim for breach of contract, is a contract implied in law. So we have a historical precedent already establishing that contractual duty. Secondly, I call it mutual exclusivity. Breach of contract cases and unjust enrichment claims are mutually exclusive. And by that I mean, as Justice Kavanaugh pointed out, that you can't recover from both. It's one or the other. If you have a contract that addresses the subject matter of the dispute, then unjust enrichment is not available as a claim. Whereas you can have both an unjust enrichment claim and a tort claim arising out of the same facts and circumstances. They are not mutually exclusive. Therefore, I think the logical conclusion is that unjust enrichment and breach of contract are so similar, they're so much the same, that you can't have the both, and therefore unjust enrichment must be premised on contractual duties.
The only conceivable difference between those, of course, is that in one case is a real contract and the other case is no real contract.
Exactly, and that's why the law under unjust enrichment imposes or implies a contract, because where there is not one, there should be one, which is why the law under equity and justice imposes one to prevent the unjust enrichment.
But there's no mutuality that exists in those 2 instances. There is in one instance, but not in the other.
Correct. The other reason why it's premised in contractual duty is we look at similar cases. Again, this not being a binary world, there are a number of equitable claims, like unjust enrichment. For example, implied contracts, assumpsit claims, writ of mandamus, quantum merit. Those cases also have been decided in this state, and implied contracts, writ of mandamus, and assumpsit have all already been held not to be barred by the GTLA. Quantum merit hasn't been decided in that respect, but it has been decided that quantum merit sounds in contract, not in tort. So if those cases, those unique cases, like unjust enrichments, those unique claims, are not a tort, why is it that unjust enrichment would be so different, so much opposite than them? And the last is, the reason it's premised on a contractual duty is under this analysis or argument about implied contracts. We know from the Rocco case, which was also recognized in the Bradley case, implied contracts are not subject to the GTLA. There are, as the court knows, 2 different forms of implied contracts, in fact and in law. Defendant would argue that because unjust enrichment is implied in law, it's not a contract and therefore it must be a tort. The reason there's 2 different, I think, implied contracts is based on the facts and circumstances that support the claim. Implied in fact is based on the course of conduct between the parties. Implied in law is based on equity and fairness in terms of imposing a contract. Both implied contracts impose a contract, and they both have the same result. Whether it's an implied in fact or an implied in law contract, the result is a contract is implied. Remember, it's a contract implied in law, not a tort implied in law. And so where there is not a contract, then the law imposes a contract to address the wrong. So for all of those reasons, I think the Court of Appeals got it right in finding that an unjust enrichment claim is premised on a contractual duty. That's only one part of the test. Yes.
What's your reaction to Black's Law Dictionary that states that an implied-in-law contract is not actually a contract, but instead is merely a remedy that allows plaintiff to recover a benefit conferred on the defendant? Does that not have some consequence in this analysis?
Well, an implied-in-law is not a contract. Reason it's implied is because there is not a contract. The question under Bradley, is it premised on a contractual duty? And I would submit that it is.
But isn't an unjust enrichment claim one which asks the court to impose what's essentially and indistinguishably an implied-in-law contract to prevent one party's unjust enrichment? Isn't that the predicate for an unjust enrichment complaint?
Yes.
Okay, so Black's Law Dictionary is still of some consequence, isn't it?
Well, yeah, but Black's Law Dictionary says it's a quasi-contract is something that's similar or resembles a contract.
No, it says it's not a contract if you remove all the flotsam and jetsam from the definition.
No, and I would just submit that because if there was a contract, it wouldn't apply. Unjust enrichment wouldn't apply.
If there was a contract,
Right.
Does that if contain anything of any consequence to you? Does it communicate anything?
No, I think under the first prong of Bradley, you determine is it premised on a contractual duty, and for all the reasons I've cited, I think that unjust enrichment is premised on that.
Couldn't you say if it's premised on a contractual duty, that is really asking us to draw the distinction between implied in fact and implied in law?
Well, no, I don't think so, because implied in fact is already determined to be implying a contractual duty and has already been held not to be subject to the GTLA. Defendant is arguing that there is a distinction between in fact and in law that makes in law something different than an implied in fact contract.
And why isn't there?
I don't think there is. Under Bradley, I don't think it matters which form of implied contract it is, because both are premised on a contractual duty.
Counsel, you're not prepared to argue, are you, that even if this is not a contract, it's still not a tort claim for purposes of the GTLA because of the second prong in the Bradley case?
That's exactly where I was going next.
So you are prepared to argue that?
Yes. I'm prepared to argue that the second prong gives you the same result as the first prong in my position.
Okay, so if I disagree with you with the first prong, what would the second prong argument be?
So under Bradley, if you don't meet the test under the first prong, then the second prong is not that the GTLA does apply. It may apply, but you have to focus on the form of liability. And under Bradley, the second prong is, does the claim being sought permit compensatory damages? So the question is, does unjust enrichment permit compensatory damages? The clear answer is no. The sole remedy for unjust enrichment is restitution, not compensatory damages. The restitution is separate and distinct from compensatory damages, apples and oranges. Restitution looks at the benefit gained, whereas compensatory looks at the harm caused. There was a very succinct explanation of this difference in the restatement, where it explains that the law of torts identifies those circumstances in which a person is liable for injury inflicted, measuring liability by the extent of the harm. The law of restitution, however, identifies those circumstances in which a person is liable for benefits received, measuring that liability by the extent of the benefit. Two different forms of recovery. So under the second prong, even if you don't end the case on the first prong and you go to the second prong of Bradley, you still reach the same result that the Court of Appeals did, that unjust enrichment does not seek to impose tort liability and therefore is not subject to the GTLA.
But as Ms. Ross indicates, in this case, as well as probably in a large number of unjust enrichment cases, the compensatory damages defined in terms of what plaintiff's loss is would be the equivalent of the unjust enrichment amount. Is that not relevant?
Well, I look at restitution as a remedy that is allowing the disgorgement or the refund of the benefit that the other party would, if allowed to keep, would be unjustly benefited by. That's not a measurement necessarily of the harm caused or the injury. It's that a party has received a benefit that belongs to someone else, and they either are failing or refusing to return the benefit. Unjust enrichment imposes or implies a contract in law that requires under restitution that that benefit be returned or refunded. I think that's different than compensatory damages in tort.
So if the plaintiff asks for the lost opportunity cost of the money wrongly refunded, it becomes compensatory and it's covered by the GTLA?
I don't. Restitution is simply to disgorge and return the benefit, and that's all plaintiff has asked for in this case.
It didn't answer the question, though. If the plaintiff wanted the lost opportunity cost, does that destroy the whole claim?
Well, that would be a question whether that's a measure of damages under restitution. Because
By your own definition, how could it be?
well, because the case law in the restatement also is very clear that the sole remedy under unjust enrichment is restitution. I think the question is, can you also have other forms of recovery in addition to restitution under unjust enrichment? And I don't think that's the case. I think the law is clear that restitution is your sole measure.
Counsel, I don't mean to be difficult here, but if you can transform an unjust enrichment claim into something that allows you to pierce the veil, as it were, of the GTLA, why doesn't that open up things very generally to the kind of gamesmanship that might in the end erode very considerably the protections that government, for better or worse, including plaintiff government, enjoy under the GTLA?
Right. Allowing the Court of Appeals decision to stand does not create an exception to governmental tort liability, in my opinion. We're not creating a new exception. We're not creating a new claim. We're just determining whether the claim of unjust enrichment falls within tort liability or not. If not, it's not subject to the GTLA. So it's not creating a new claim that would allow the floodgates of litigation to open. In the Ross decision, the court made an important point about this issue. And that is that plaintiffs are responsible to, and will always endeavor to, plead in avoidance of governmental immunity. But it is then the task of the courts to determine whether the essential elements of a particular cause of action have been properly pled and can be proven. So it's up to the trial courts. I think that's the role of the trial courts, to determine if an unjust enrichment claim is pled, is that proper in that case, and is it supportable as a claim in that case? That doesn't open the floodgates of litigation. It is always kind of the analysis of determining whether a particular claim is subject to the GTLA or not. The one last point I would make is that I think to go a different direction than the Court of Appeals decision actually can create a conflict in the law. And maybe and by that I mean, we talked earlier about there being mutual exclusivity between a breach of contract and an unjust enrichment claim, because they're so much the same, you can't recover from both, it's one or the other. If there was law that held that unjust enrichment claims are really tort, are we now opening up a conflict or an issue that in contract actions, can you now recover from both? Because there's been a determination that unjust enrichment is now considered a tort, and so should it be mutually exclusive to a breach of contract claim?
Thank you, counsel. Your time is up. Appreciate it.
Thank you.
Sorry, Ms. Masseron. Case will be submitted.